Do what?
Okay.
You're now what?
Now live. Okay. All right. It is Friday, April 9th?
8.
8th. Okay. April 8th. And we are here, meeting of the Sexual Harassment Prevention Panel, and we are looking at our policies and procedures to revise the 2018 procedures and panel and policies that we voted on in 2018. And we were here with our human resources person, Arlene Donovan, Council Damian Leonard, member Representative Bloomley, member Representative McCoy, Representative Marecki, Representative Feltus, and I'm Representative Burke. And on Zoom, we have Council Jen Carby and Katie McLean. Okay, I think we've got everybody. And Mike Ferran, thank you for facilitating this meeting. So we were just having a quick little discussion about facilitators, and it's determined that the facilitators should be non-panel members. So how shall we go about deciding this? Should I take some suggestions from people, and I'd be happy to follow up and see if the people we suggest are interested, or how? Anybody have any suggestions about how we should proceed with this?
How many do we have?
3.
The policy says up to 3.
Or do you want to think about it and you know, send
I can send you.
why don't we
Questions.
sort of on the spot? So just think about people, look around the chamber, when we're in session, think about people who might be well suited for that job.
Yep.
And willing to take it on. Okay, great. All right, terrific. So I guess now we need to continue a discussion or begin the discussion of procedures. Right?
Yep.
Okay, that's where we are. So
Let me pull those
try to
up,
get there.
and
Does everybody know, and maybe for the people, anybody who's listening, if you go to the legislative webpage and you go to committees, and there's a committee sexual harassment prevention panel, we have our own webpage, and under documents and handouts, Friday, April 1st, click on that link, and there are 2 documents there under Damian Leonard. And one is the sexual harassment prevention panel rules of procedure. And that's the one that we're going to be looking at right now.
And it's listed as house panel. I was looking for sexual harassment in alphabetical order, and it
Yeah.
wasn't there.
That's
All
right.
right, yes, sorry, forgot that step. Under house committees, right?
Okay.
Well, even in the other one, but it's called house.
Yeah,
not
Yep.
So
sexual.
is it under April 1st?
yes.
it is under April 1st, yeah.
But it's not a joke.
No, no.
That was last week. So do we,
That was good.
The first one,
you have it? Yeah,
procedures.
rules of procedures. Yeah, because now remember, we're separating out the policy from the procedure, which is, I think, excellent. Yes. Okay.
Okay. Good morning, everyone. For the record, I'm Damian Leonard from the Office of Legislative Counsel. So what I did when I prepared this discussion draft was I split things up into individual rules. So that it would look more like a regular legislative document or a set of judicial rules. What it'll also do is going forward, if you want to make an amendment, but it's really only Rule 5 that you want to amend, we could just work on an amendment to Rule 5. So we can work in much more discrete chunks going forward. So Rule 1 is just the definitions for the rules. Complainant is defined as the person who has experienced or believes they have experienced sexual harassment or retaliation in violation of the policy and has contacted the panel regarding the alleged violation. An investigator is an attorney or another independent individual or entity with expertise in the area of workplace harassment with whom the panel has contracted to investigate the allegations in a formal complaint. Panel is, of course, this panel. Panel staff mean employees of the Office of Legislative Human Resources, Legislative Operations, and Legislative Counsel who provide administrative, technical, and legal support to the panel. Because we are a little bit of a rotating group, I didn't want to specify anyone in particular and just left it general. Policy is the House policy for the prevention of sexual harassment. Potential complainant means a person identified by a witness or another individual as a person who may have experienced sexual harassment or retaliation in violation of the policy. Regulated individual means a member of the House of Representatives, the clerk of the House, or an employee of the office in the office of the Speaker or the clerk's office. So that's important because we're looking at just the House with this policy and these rules of procedure. The reason for this is that the joint panel has jurisdiction over employees in, for example, legislative operations or legislative counsel, or the sergeant at arms office who have a complaint filed against them. So there would have to be basically a mirror set of rules of procedure for the joint panel, and then likewise for the Senate panel. And then finally, supervisor means an individual employed in a supervisory role in any office of the General Assembly. So this could be Jen Carby, the Chief Counsel at Legislative Council. It could be Arlene Donovan, our Head of Human Resources, Mike Ferrand, our Director of Legislative Operations, Catherine Benham over at JFO, et cetera. And the reason we've called out supervisors is, as we mentioned before, supervisors have a legal obligation to ensure that their workplace is free from sexual harassment. So if they become aware of it, they have to take steps, whether that's contacting the panel or taking appropriate steps within our office to address the situation. Are there questions on any of the definitions? Okay. So informally contacting the panel, what I've done here is I've tried to mirror our existing procedures as best as possible and just break them into discrete sections and subsections, the same as we would a bill. So any person can informally contact the panel to discuss an incident or conduct without initiating a formal complaint. To the extent possible, the identity of the complainant or potential complainant would not be disclosed without their consent. In B1, if the complainant discusses an incident or conduct with a panel member, the member is required to explain the policy and the different options for resolution, including informal resolution under Rule 3, or the formal complaint process under Rules 5 through 17. If a witness discusses an incident or conduct with a panel member, then just like in the existing policy, based on the information provided by the witness, the member shall approach the potential complainant to discuss the incident or conduct and to determine if the potential complainant would like to pursue an informal resolution or the formal complaint process. And then the panel member has to inform both the potential complainant and the witness that, and this is interesting actually, this really should be broken out, and this is why we do this. The next sentence here about the panel member informing both the potential complainant and the witness that regardless of whether they wish to pursue the incident, a resolution, the panel is obligated to take immediate and appropriate action to make sure the conduct doesn't continue. That really needs to be its own separate subdivision because it applies in both situations. And as I've explained before, if the panel makes a determination that the conduct was a one-time isolated incident, there might not be any steps that need to be taken. More likely than not, though, the panel may need to take steps that could include a safety plan with the individual who was harassed, which is planning on how they're going to avoid that situation, speaking with the individual who engaged in the harassment informally, speaking with their supervisor. It depends on the situation. But more likely than not, you'll need to take some sort of interim step just to ensure that the behavior stops, even if there's no formal or sort of official informal process initiated. So it may just be an informal contact between the panel and that individual just saying, hey, look, we got a complaint. We're aware that this behavior may have occurred. Nothing's being pursued, but that behavior needs to stop because we don't want to have an incident, another incident like that occur at this point. So, and that's in each of these instances, it's going to be a sort of case-by-case assessment of the situation and exactly what's happening and who the individuals involved are. One other thing I would note just as I'm going through this is it should be, there we go. That's in the next paragraph. So if we go over to page 2, it's the other thing to note is the next paragraph deals with supervisors or an employee of the Office of Legislative Human Resources. So based on the information provided to that supervisor or employee from Human Resources, the member again would approach the potential complainant to discuss the incident or conduct and determine whether they want to pursue an informal or formal resolution. And again, that language at the last sentence there could be broken out. So we just have a subdivision 4 that provides this for all 3 of these paragraphs here. So this was carryover, I think, from the last draft, or just language that fell on the editing room floor when I was editing it and should have realized that it was just repeated and needed to be repeated too for paragraph 1. So in every instance in which the panel is informally contacted under subsection C, the member has to inform the potential complainant. And this is actually covers all of the language there. So again, I apologize. There's language here that just needed to be edited out. So this requires the panel member is required to inform the other panel members. So you can't keep it a secret. It has to at least be among the panel members so that if another incident happens, the panel members are aware that there is a pattern instead of potentially 3 different members being contacted about 3 different incidents and not realizing that there's a pattern of behavior occurring. That the panel may need to gather additional information and that the panel is obligated to take immediate and appropriate action to ensure that any conduct that violates the policy doesn't continue. And then you'll notice on subsection D that I've noted in brackets here that we may want to include language about working in consultation with the Office of Legislative Human Resources and or the Office of Legislative Counsel and outside counsel. And you'll see this throughout the rules here that I've put Office of Legislative Counsel / outside counsel. That's really a decision point for the panel here to decide when you want to involve legislative counsel and when you would prefer to have outside counsel. And I can discuss sort of the complications around legislative counsel being involved at certain stages in the process, which really creates a conflict of interest for us, particularly if the complaint is against either one of our colleagues or a member that we work for. And then so if you can imagine a complaint by one member against another member, and then with the panel, and the council may work with both the panel or the member being complained against and the member filing the complaint, you can imagine the sort of conflict that would put us in terms of trying to keep our regular work, our legislative work, separate from our panel work, while also respecting the client relationship, we have with each and every one of you. So that's an instance there where, you know, if you do have a formal complaint, that might be a very potentially good instance to just say outside counsel that the panel keeps on retainer would provide advice at that point, so that you basically have independent legal advice where there isn't that sort of tangle of relationships that comes from working so closely with everyone in this building. But that, I think it's a decision point, so I've left it out there, and you'll just see I've highlighted it throughout the draft. And there are points where you may decide it's not necessary to bring in outside counsel until we get to, for example, a formal complaint, or, you know, maybe it's keeping legislative counsel on for amendments to the rules, working with Office of Human Resources throughout the process, and then working with outside counsel in relation to complaints or something like that. You know, there are different ways to formulate this.
So, Damien, you mentioned and or, but it's just and. So
It
are
is,
you thinking?
and so I think involving the Office of Legislative Human Resources is a good idea at any step of the process. It's also something that in the draft policies for the staff office, the supervisor gets approached about any complaints of sexual harassment, or that might be sexual harassment or discrimination for the other panel here, that they involve human resources, so that they have someone who understands the law, understands the steps they need to take for an employment related matter, and how to ensure that they're doing things the right way. And that way we avoid missteps and we keep the process consistent from office to office, which, because we have several different offices, there's always the concern that offices handle things slightly differently, not out of any malicious intent, but just because they have slightly different understandings. And then there becomes a perception that, you know, one office may treat these incidents differently than another office, and that could lead to a bad perception. If you have human resources involved, you ensure that the approach is consistent. And that way you avoid any perceptions that maybe there was favoritism or whatever the opposite of favoritism is in one incident there. And you can just ensure consistency and clarity throughout. But so I would definitely recommend keeping human resources involved, particularly for anything that's involving an employee. If it's a formal complaint going to the point where you may be considering disciplinary action, having human resources involved to help you walk through exactly what that looks like would certainly be helpful, I think. I mean, I don't want to speak for Arlene, but obviously Human Resources doesn't have jurisdiction over disciplining members, but certainly could be involved in discussing some of the issues around that.
Go ahead.
Yeah.
Oh, no, go ahead. Are you?
The question that I have is, say something comes up and it's more like a formal complaint, but we just sort of want to check in with you, legislative counsel, to say, do you think that this merits, you know, going to human resources, or you know, just for a little bit of advice? Would that be okay, or should we just bypass you completely and just go right to Arlene?
So I think part of this is it's a good discussion point. I know a lot of times Arlene and I will talk if an issue comes up, and we'll discuss, you know, so these are the facts. You know, what's the potential legal issue here? Is there a potential legal issue? But it's, you know, I don't know what makes the most sense at that point. It might be worth discussing a little bit more about, you know, because one thing that Arlene can do, just putting an idea out there, is she can take down the facts without identities and say, here's a fact pattern. Is this a potential violation of the complaint? The other thing too is we could potentially, I mean, you could keep ledge counsel involved at the informal level. And then if it goes to a formal complaint investigation, you bring in the outside investigator or outside counsel to conduct the investigation and advise the panel through that process. You know, so there are different ways to handle this. And certainly with the formal complaint, the complications with potential conflicts become greater. With the informal resolution, even with that, there is definitely some of that uncomfortable overlap. So,
Well, we could just say, go directly to Arlene. And then, as you say, you can take down the facts, you might need to consult with counsel, et cetera, and proceed from there. I mean, maybe that's the cleanest thing to do instead of having a little bit of, I don't know, what do other people think?
I don't know. Ledge counsel works for us, so they're our attorney. I don't want to completely,
Yeah.
I like it this way that, you know,
Yeah.
we could certainly go to Arlene, but I certainly want
Okay.
ledge counsel to weigh in
I mean,
as well.
the other thing to note too, and Jen and Katie can feel free to chime in if I'm getting off track here. But the other thing to note too is there's no requirement in many instances that if you were to call me and consult on, is this a violation of the policy, or Katie or Jen, there's no necessary need for you to say, here's the identity of the member, here's the identity of the other individual involved. You know, so the complainant, and it's a complaint against a member, you know, it could just be, we have a complaint.
Yeah, okay.
Yeah, we have a complaint from a member of the public against a member. This is the allegation. And that gives me, or it's a complaint from one employee against another employee, or, you know, whatever the facts are, just kind of the bare facts of, you know, the behavior occurred at the State House. It was between these two individuals without identifying their names, but just sort of saying like two people who work in the building, or a person who is from an outside agency that was in the building and feels they were harassed by someone covered by the policy. And then describe the conduct. And then at that point, we can kind of say, okay, this fits here. And then that also prevents us from being in the situation where we're like, you know, oh, it's person A and I'm going to be seeing them in 10 minutes. And now I know they've had a complaint filed against them and this allegation, and I have to work with them on an amendment this morning. And, you know, so there are potentially all these overlapping issues. And I mean, the other thing that happens for us, and for me in particular, because I work on the employment laws too, is that members will approach me with questions, and staff will approach me with questions about things they've experienced in the building. And so sometimes I'm in a position where I'm talking to a member of one of the panels about behavior that they've been approached about. And then at the same time, someone else involved in that incident has approached me separately. The facts don't always line up. And it gets challenging to sort of keep those conversations separate. And so that's just one of these reasons why at least doing it without attaching names to it for ledge counsel could also help that. Although, again, in that situation I just described, sometimes it's very easy to put the two sets of facts that people tell you together and be like, okay, I know exactly what we're talking about here. But it does, that, you know, could potentially help a little bit.
Should we put in something like, specify that names will not be, is that necessary? Names will not be revealed or something? I don't know.
So I'm about to head out to a committee, but Damien, maybe this is something that you and Katie and Mike and I can talk about when we meet later today to come up with some ideas that make sense to us.
That sounds like a
great.
great idea, Jen. Yeah, so maybe we'll rough out some options
Great.
and then we can we can work on that. Because I also, Jen pointing out that she has to run the committee reminded me that we're already up to 9 o'clock and I'm only on rule 3.
Okay.
So rule 3 is the informal process. So if an informal resolution's requested, promptly inform the other panel members. The panel would gather information as necessary and shall consult again with Ledge Human Resources, Ledge Council, outside counsel as appropriate. Again, we can just bracket that information. And then 2 or more panel members, just like under the existing policy, would meet with the regulated individual to attempt the informal resolution. We create a brief record of the incident or conduct that's kept confidential, but is available to the panel in the future. And then following the informal resolution, there's just prompt notice to the speaker that there was an informal resolution, but with no information about the particulars of the incident or the individuals involved.
So we'll ask one quick question. So the panel, 2 or more panel members shall meet. And that is, alone, right? Without Ledge Council or,
Yep.
Okay.
Yeah, so that's, it is silent on whether you might bring Ledge Council or Human Resources or someone like that along. There is that option, but it really is directly the 2 or more panel members. And the reason we do 2 or more is just so that there's corroborating witnesses.
Yeah.
And that's, you want to make sure that there are at least 2 people from the panel who can explain what happened at that meeting and corroborate that their versions are identical and can keep a record. And typically the way that works with like a conversation, if we were to deal with like an employee incident, is one person would lead the conversation, the other person would take notes on the conversation and kind of memorialize, like, okay, we discussed the incident, the individual explained that that wasn't their intent, but they're sorry that the incident occurred, they've agreed to apologize, and not to do that again. And then incident might be resolved at that point. That's a good example. And then you have a short record of the conversation and when it occurred and who was present. The panel would keep that on file, and that would be it. Do you have anything to add to that,
No,
Arlene?
that's exactly right. It's important. We would always recommend having another witness in the room, and I think it's important that one person can focus on the conversation while the other person takes the notes, rather than having one person trying to do all that. You miss things in that process. So
Where do those files live?
Right now, those files live in a locked drawer in my office. So, but that's another thing that we may want to talk about going forward, whether it makes sense to keep them in locked files at the Office of Human Resources now that we have an Office of Human Resources, or otherwise. But right now, I've been keeping the files in a locked drawer in my office. So, yeah. The preventative action. So we've talked about this already a couple of times. This is just the rule providing that if there is, if the complainant elects not to pursue the process, the panel may need to take preventative action. And under subsection B here, let me just keep the screen scrolling forward. If the panel determines in consultation with Legislative Human Resources and either alleged counsel or outside counsel that the alleged incident or conduct could constitute a violation, the panel shall gather information as needed and then take immediate and appropriate action to prevent any further violations of the policy. So one thing to note here too is sometimes you will get complaints where the behavior may have been unpleasant, but it's not a violation of the policy. And so in those instances, again, working in consultation with human resources, ledge counsel or outside counsel, you kind of determine what an appropriate next step is. If it's borderline behavior, it might involve a conversation with the individual, or it may involve discussing with the person who complained of the behavior, sort of where the policy fits in and why the behavior lies outside that, and talk about alternative resolution options with them. Rule 5 gets us to filing a formal complaint. So if the complainant decides to pursue the formal process, they have to submit a written complaint. It does not need to be in a specific format, and they may be either written by or on behalf of the complainant. There's 2 reasons why we allow it to be written on behalf of the complainant. The first is sometimes if you've experienced a traumatic event, it's hard to put that down on paper, and it helps to have someone there to help you put your thoughts in a logical order. The other is that if you have an individual with a disability who may have trouble writing and doing a written complaint, then this would allow them to get someone to help them formulate the complaint in a format that can be reviewed. So this just ensures that we're making the process accessible to everyone, whether they're able to do it on their own or whether they need the assistance of someone else to help get the experience on paper for the panel to review. And then in 2A, this would be a change from the current policy here. And this is something we discussed back when we started revising the policy, is allowing the submission of an electronic copy of the complaint or providing a signed physical copy. You'll notice that I didn't say submitting a signed electronic copy. And the idea is that if someone sends it from their own email address, that would replace the signature there. You know it's coming from them.
But the complainant needs to submit it, not their friend who.
That's right. So, right. So they can have assistance writing it, but they need to send it from their own email address, or they need to provide a signed physical copy. And then the chair would make sure that the copies are provided to the panel and staff as appropriate. If a panel member other than the chair receives the complaint, the member shall immediately notify the chair and allow the chair to provide the panel and staff with the complaint. The complaint would include a description of the conduct at issue, identify the regulated individual, and the complaints can be submitted again against a current regulated individual regarding conduct that allegedly occurred at any time during which they were a regulated individual. So if you've been a member of the House for 20 years, you could have a complaint submitted about behavior that occurred years and years ago, as long as you were a member of the House at that time. And again, upon receiving a complaint, the chair shall promptly inform the speaker that the complaint has been filed, but not of the identities of the individuals or the alleged conduct. Rule 6 provides for the response to the formal complaint by the respondent. So the panel provides a copy, and then the respondent, I've put in brackets here, within blank days, and then the panel may extend the time for the respondent to file a response for good cause. This is a change that the discrimination prevention panel put in to provide some sort of structure around the timeline here, so you can decide on an appropriate number of days. And then one thing that panel did is they've allowed for extending that time for good cause. So for example, if someone is, say a complaint comes in over the summer and the respondent is out of state on vacation or something like that, then that would be good cause to say, yeah, we'll give you an additional 5 or 10 days to respond.
Madam Chair.
Oh, sorry.
So what does the discrimination panel response time?
I will look that up
Okay.
and get that for you. I think it's 7 days.
7.
It might be 5, but it's it's about a week turnaround time for them. And then they, allow for the extension there in the event that for whatever reason, the individual needs additional time.
Okay.
And then the good cause standard is something that's really up to the panel to judge whether the requested reason is good cause. And then again, copies of the response are provided to the complainant. The initial review occurs after receiving the response. So this is similar to what happens in court. You get a complaint, you get an answer to the complaint, and then you can, at that point, the parties often will file for summary judgment or dismissal. This is the point where this panel would do an initial review to say, as soon as practical, to make an initial determination whether, if the allegations in the complaint are true, would it constitute a violation of the policy? So assuming that based on the information in the complaint, everything that's alleged occurred, could that be a violation? If the answer is yes, then the process would continue and you would start to gather more facts. If the answer is no, then at that point you could dismiss the complaint. And then the panel will consult with human resources, alleged counsel or outside counsel to make that initial determination. And the chair would request from panel staff that the staff provide copies of any prior complaints against the respondent to determine if there's a pattern of conduct. And then if the panel determines that the allegations are true, it would proceed to the investigation. If not, there's a dismissal. And so this is all under B. And then if you do dismiss, the chair again notifies the speaker of the closure, but not the incident or conduct or the identity of the individuals. And then in C, and again, this is from the existing policy, if the allegations relate to a matter at issue in a pending criminal proceeding, and the respondent is the defendant in that proceeding, the panel may choose not to take any further action until the criminal proceeding is dismissed or no longer subject to appeal. And then if the panel decides to stay action, it would promptly notify the parties of that decision. So Rule 8 is shorter. If you determine that the allegations could constitute a violation, the panel is required to contract with an investigator to investigate the allegations. So this would be an outside attorney or other entity with experience in workplace investigations. And the contract would outline the scope of work to be done, including a requirement that the investigator produce a report with a determination as to whether the policy has been violated. So.
I have a question about
Yeah.
that. We talked about it before when we did the other policy. Would the outside investigator be the same as the outside counsel?
That's actually, that's a great question. And that is something that you could basically replace shall contract with an investigator to shall request outside counsel to conduct an investigation and produce a report.
What I mean is like the outside counsel who we were talking about earlier, in lieu of
Yep.
alleged counsel. And then the other issue is, do we need to have somebody like designated who is agreed to be that person?
I would have someone on retainer, yes.
Yeah.
And we do have some options and can produce more. And then the panel can decide who it would like to engage, and then you could put them on retainer. And that way they're available if something happens. And you can immediately engage them. And this could be the outside counsel. I know the New York State Assembly has a law firm on retainer for sexual harassment complaints. And the complaints, if it's a formal complaint, it goes directly to the law firm. And the law firm performs its investigation and then meets with the House or the Assembly panel to discuss the allegations and what their investigation turned up. And so for them, it's the same outside counsel who's providing information to the panel on the legal facts here is also doing the investigation.
I think
Sorry.
I think that makes sense to hire outside counsel who then, and I don't know, it's written in the contract that we have with them, I would assume, to seek the outside counsel, but they do they contract with whatever investigative person they would need.
Okay.
And then they come back, the council itself comes back with a report, and if the investigator comes with them or something, but that's the thing that makes most sense to me. I wouldn't feel comfortable going out and hiring an investigator without having counsel at the same time. It just doesn't. I wouldn't be comfortable with that.
And does that need an appropriation?
Well,
Yeah, I mean,
we all there's a budget for, I presume we're not talking about thousands of dollars, but I don't know.
no, Arlene might have a better sense of the cost related to that. But yeah, that's something that you would need to budget for this panel. And the discrimination prevention panel is going to need to do the same thing. And, so it's something that addresses these situations, like I was mentioning before, where inside counsel has basically got a conflict. We work for everyone. And so this allows you to get a neutral third party that comes in, has experience with this, can advise you on the law and on your policy and on the behavior that occurred and what they found in their investigation.
Could the outside counsel potentially be the same for sexual harassment and discrimination?
Potentially, yep.
And so we could keep one firm on.
Yeah.
Yep. Yeah, that
And
is, yeah. I mean, the
Ethics
key is you want to make sure that they've got experience in those areas.
Right.
And certainly for workplace discrimination and workplace harassment, I imagine there are any firm that specializes in one has got a specialty in the other because they overlap so much. With respect to ethics, I'm not sure, but there may be a firm that does both, or it may be that the ethics panel retains its own counsel.
An outside counsel and the investigator could be just one and the same.
Yep, they could all be from the same firm. So, and of course, the other option is, outside counsel may just have an investigator that they work with, or it could be attorneys from that firm or people who are kept on staff at that firm who do that work. So it's going to vary from firm to firm.
Well, if we're talking about $10,000, that's one thing. If we're talking $50,000, that's different. And I would presume that would be part of the human resources budget.
Potentially. Yeah, we'd have to talk. I mean, I know Arlene is also, is there a budget request in for outside counsel, or I'm sorry if this is bringing us way off topic.
I did roll the potential if that's something that we wanted to do. So the retainers I called just not for this specific, but for outside counsel in general, in case there was a conflict with a labor issue. And the retainers seemed to be around $5,000 for the contacts that I had made. The cost though would go up once the retainer runs out if they were on a case that was very involved or something like that. So those are the numbers that we wouldn't be able to predict.
Yeah, I mean, if you're in an involved case, you can imagine your legal costs are going to be at least $200 to $300 an hour. And then it's going to depend, but a mid-level, well, this is almost 10 years ago now, but a mid-level associate 10 years ago was billing at $200 an hour. So, and fortunately we're not in Boston or New York where, we'd be talking 2 or 3 times that, but you could expect that the cost would be probably average around $200 to $300 an hour.
Well, an average retainer cost could be rolled into the budget for the Office of Human Resources, which is all part of the legislative offices. And then if an instance came up where we had to spend $10,000 or $20,000, we just have to handle that separately.
Yeah.
I mean, it could get covered, certainly. but
Yeah.
It would be handled in a budget adjustment process or something.
Glad you're here, Marty.
Yeah.
And
I'm saying they would all approve it, I'm sure, but
so will you start to investigate like some appropriate programs, or how will we proceed? with that?
We have a list of some, and we can present that at some point to the panel. And yeah, I think Arlene's got more information on that than I do, but I know that when we were looking at this a couple of years ago, Luke had worked up through contacts with the Human Rights Commission a list of I think 4 different investigators, and I think some of them belong to law firms, while others were independent. So the ones who belong to law firms, we could add to that list and get a sense of what the retainer is.
And we can see what they cover also. If they would
Yes.
cover discrimination and sexual harassment and maybe ethics as well.
Mhm.
So it might make.
I think that would be
Yeah.
preferable.
Yeah.
Because I hope we don't have very many cases. If we just have one retainer, and for-
Mhm.
that would be more streamlined, certainly.
Okay,
Great.
I think we can go, it's 9:20.
Yeah, what's your preference, Madam Chair? Another 5 minutes. So Rule 9 is review of the investigator's report. Once it comes in, the panel promptly provides a copy to the parties. The panel would review that report and make a preliminary determination as to whether there was a violation based on the findings in the report. And if the panel makes a preliminary determination based on those findings that there was not a violation, so the report comes back and gives you a basis to believe that there's not a violation, the complaint's closed. 2 or more panel members would meet with the complainant and the respondent. You can meet either separately or together. I'm sure it's going to vary by the incident as to what the parties want. To summarize the basis for the determination, and then draft a brief letter summarizing the decision without any identifying information that's provided to the parties. And then again, notifying the speaker that the matter was closed, but not of the incident or the identities. If, on the other hand, under D, if the panel makes a preliminary determination that the respondent committed a violation, then 2 or more panel members would meet with the respondent or the complainant, and the complainant either separately or together, to review the documents or evidence in addition to the investigative report. So any other documents or evidence the panel has, and involve them or inform them of the basis for the determination, and then shall take further steps as set forth in Rule 10. So which is actions following preliminary determination of a violation. The first is under subsection B, which is issue a written warning to the respondent. And then again, there is information there about providing a brief letter to the parties summarizing the decision, but not providing the identities. And then also promptly informing the speaker of the disposition, but not the specifics. Another option is entering into a mutually agreed to resolution. This would likely be the instance when the parties might want to meet together to review the complaint. And then the panel can attempt to negotiate a resolution. If the parties agree, they would be provided with a copy of the terms of that resolution. And then the chair would promptly inform the speaker of the disposition of the complaint, but not the specifics. And then the final option is to draft and present charges and set the matter for a hearing. This would be for particularly egregious incidents, most likely, or or potentially incidents where the parties do not agree with the report and the findings in it and are still arguing. And then at that point, you could allow them to present evidence and witnesses and so forth. So the panel would draft the charges, provide the complainant and the respondent with the charges and a time and location for the hearing, allow the respondent to file an answer to the charges, and then promptly inform the speaker that the panel has drafted charges, and in this instance of the incident or conduct at issue, but not identifying the parties. And then the complainant and the respondent can jointly agree to waive the hearing at any point in the process. So in other words, after you've drafted charges, they could at that point agree that they don't want to proceed with the hearing and are willing to go to, for example, in a mutually agreed resolution or something.
Throughout, the speaker does not know the identities.
No.
Okay.
So,
And does this involve, I mean, I guess this could incorporate a mediated, I mean, that's what we're talking about, right?
yeah, I mean, the idea here is just like with the judicial process, at any point up to the hearing date, the parties might agree to settle the dispute. So they
I
may.
just wondered about whether we might want to have an actual mediator, and I suppose that law firm might have somebody.
It's something you could it's something that you could potentially propose. Right now, it's the panel is allowed to attempt to mediate, but you could, it's an additional cost. So that's something to keep in mind, but you could potentially put in language that allows the panel to engage a mediator if the parties request it, to attempt a mediated resolution of the issue. So that is an option. Do you see concerns with that, Arlene?
What do you think, panel members?
I don't think so. I think I'm trying to think of what the potential issues could be there, but wondering if it was a separate mediator maybe from the person who's doing.
Yes,
mediation.
yeah, I think it would be a separate individual doing the mediation, because you want someone who's trained as a mediator.
Yeah.
And some attorneys are trained as mediators, but not all attorneys are trained as mediators, nor are all attorneys good mediators. So
Not being part of the training.
yeah, and I mean, there are different personalities. I mean, the personality that makes a good litigator can be very different from the personality that makes a good mediator.
When you want a good litigator, you want a good litigator. You don't
Right.
really do.
So, there are different skill sets, and certainly different experience levels, and you'd want someone who's experienced in mediating workplace disputes, as opposed to someone who mediates collective bargaining disagreements or something like that. One thing I would note is that the roster of mediators in Vermont and alternative dispute resolution professionals is somewhat small, but it's something that could certainly be looked into. And again, or outside counsel might have a list of people that they use as go-to, or that they know and respect within the area. So I would defer to them to get a list, and Arlene may be aware of resources on that too.
Well, we may want to put that option in here, where it says the
Okay.
panel may attempt to negotiate a resolution, or they may contract with an outside mediator.
Okay, I'm making a note. And I'll put it in. All right.
Thank you so much.
All right, so we'll pick up at
Before the floor.
Rule 11
And we
next
will
time.
meet next Friday.
Next Friday.
Yeah, and hopefully we can.
Kind of a regular gig here.
It's a regular gig, but it has an end point.
But it
so
does have an end.
That's
Thank you very much.